And I'd like to welcome you all to our Tuesday 1:30 p.m. session today with the Legal Counsel for the Elderly, talking about life planning, such as wills, trust, and powers of attorney. I'm going to go ahead and read our disclaimer before we get started. The WildTech DC Senior Digital Equity Program, its owners and presenters offer technical assistance, virtual health, well-being information designed for educational purposes only. You should not rely on the information and any apps or topics made by WildTech, including but not limited to mobile device applications and any social media pages maintained by WildTech, its owners or presenters as a substitute for professional medical advice, diagnosis, treatment, or legal advice. Thank you so much for letting me read the disclaimer. If you cannot see us, hear us, or see the screen, please let us know in the chat. We would appreciate that. Let's make sure to keep our TVs and cell phones in mind so we can give ourselves the most immersive experience. And as always, make sure you take notes and or screenshots so you could review the information for later on. But yes, this session will be posted on our YouTube channel so you could review and replay it as much as you'd like as well. Lisa, if you could introduce yourself and your topic for today, I'd really appreciate that. And thank you once again for presenting to us today.
You're welcome. Hello, everyone. Good afternoon. It's great to be with you again. If it comes to a point where you don't hear me well, if you can let me know, put it in the chat or just come off mute and let me know that you can't hear me well. I'd appreciate that. I am going to be talking about life planning. That includes powers of attorney, last will and testament, and also trust, because I believe some of you are specifically interested in that topic, trust. You can feel free to ask questions at the end of each section of the presentation. And I'll be happy to answer your questions. I'm going to start by just talking a little bit about legal counsel for the elderly. I know you have heard this before, so I'm going to go through this real quickly. Legal counsel for the elderly champions the dignity and rights of Washington, D.C. elders by providing free legal and social work services to those in need, empowering, defending, and protecting vulnerable seniors. Next.
Oh, yes. Thank you, Lisa. Again, we may have some new seniors on as well for our session today. So again, we really appreciate you all continually coming on and going over these topics. Thank you so much.
Absolutely. Legal counsel for the elderly has been providing free legal and social services for almost 50 years now. The work that we address includes those aspects of an adult's life that are most important, including housing, economic security, self-determination, and health and safety. We impact the lives of nearly 10,000 people annually while advocating for citywide reforms in laws, regulations, and long-term care facilities. Next slide, please. Just to go into a little more detail about those areas, with regards to housing, we help people avoid eviction and foreclosure and address housing code violations. Economic security, we help people secure public and veterans benefits and tax rebates that they are entitled to, while also helping people avoid scams and financial exploitation. Next slide. Self-determination is helping create wills, powers of attorney, and transfer on death deeds. Health and safety, we help people receive health care and safety that they're entitled to. So for instance, people may need help with Medicaid, applying for Medicaid or the EPD waiver. In terms of advocacy, we take the lessons that we learn from our clients and advocate for changes to citywide laws and regulations. We also engage hundreds of pro bono lawyers from area law firms, corporations, and government to provide direct client services and support our advocacy efforts. Next slide. Today, like I mentioned, I'm going to be talking about the area of self-determination. So helping to understand the different documents that go into that, powers of attorney, wills, trust. So this slide here shows different types of documents that someone can use, and it goes from the less restrictive type of document to a more restrictive type of decision making for an individual. So in there is, you see, powers of attorney considered less restrictive. More restrictive would be court appointed guardians or conservators. Next. Okay, I'm going to start now by talking about financial powers of attorney. A durable financial power of attorney allows you, the individual, who we call the principal, to appoint a trusted person, who we call the agent, to handle financial matters for them, really financial and legal matters, okay? We call that financial power of attorney durable because it survives if a person becomes incompetent or has an incapacity. In other words, if you get a financial power of attorney put in place today, and then tomorrow you lose capacity, the document continues to be enforced, even though you have a different situation. The reason people get financial powers of attorney are to avoid guardianships. Again, guardianships are considered more restrictive, and that's where a court appoints somebody to make decisions for you. It also allows people to get the assistance that they need. So for instance, somebody may not be able to do their own banking, or may not be able to engage in selling property for themselves. So this type of document allows an individual to get assistance. And keep in mind that those powers that the agent has can be either broad or limited. And when we talk about broad, again, you see at the bottom here, another term is general. A general power of attorney means it covers all aspects of a person's life, whereas a limited power of attorney means that either it only covers certain areas. For instance, somebody might say they only want their agent to be able to sell property for them. They don't want them to be able to engage with their credit cards or banking or anything else, only to do this one limited thing. Or it could mean that the powers are limited for a certain period of time. So let's just say this power of attorney is effective for the next 5 months. And after this 5-month period, the agent has no powers with regards to my finances or legal matters. Next slide. A power of attorney becomes effective, a financial power of attorney becomes effective either immediately, okay, so that would be indicated on the form that it's effective on the day that you sign it, immediately, or it's effective at some later point when some triggering event occurs. For instance, it could be effective only if the person loses capacity. And once that occurs, then the powers become active. Keep in mind that a power of attorney is void once the person dies. Okay, it's only effective while we're living, and it is, it can be changed or revoked as long as it's done in writing. So if you have somebody listed as your agent, you can always change to somebody else, or you can decide you just don't want to have a financial power of attorney any longer. In DC, the requirement is that a financial power of attorney is in writing and that it be notarized by a notary. Also, 2 witnesses are recommended but not required. Next slide. Okay. Keep in mind that if you do want somebody to be able to have power over real estate, so for instance, to be able to sign a deed for you, there's a special clause that needs to be in that financial power of attorney. And there's something that you need to do with regards to that. So keep that in mind. We also don't recommend co-agents. However, people, know their own circumstances. Sometimes people have, for instance, two children. They believe the children can get along all right, or well. And so they want to make them co-agents, which means they have to agree on decisions. We recommend more that you have one person in place and then have a backup. Okay, so that would be described as a successive agent relationship. So one person is the agent. If that person is unable to or unwilling to serve, then you have another person. You can also have, if that second person isn't willing to or is unable to, you have a third person. So you can really list as many agents as you want. You can also include in your power of attorney that if it so happens that a guardian becomes necessary, okay, most likely it's not, because that's the purpose of the financial power of attorney, to avoid guardianships. But you can include in there that if that becomes necessary, you want to state who you want to be the guardian. Okay, so while you have capacity, you're telling the court, for instance, if I have to have a guardian, this is the person I want. A the person who's getting the power of attorney can sign with an X or with their initials. There can also be a designated signer. Sometimes people don't have the ability to sign at all. There's some reason why they're not able to use their arm. So somebody else can do it. And we would just indicate that on the form, that the individual who's getting the document done approves of this designated person to sign for them. The person cannot be the agent. So the person who signs can't be the person who's being made the agent. So it needs to be some third party. Keep in mind that the federal government uses representative payees for Social Security and OMBs instead of a financial power of attorney. And also the VA has their own financial power of attorney that they use instead of the ones that we produce, the ones that you could get, or even the rep payee. The VA has its own document. Next slide. Okay, I'm going to ask if there's any questions regarding the financial power of attorney before I go to the healthcare power of attorney. Does anybody have any questions?
Yes, please. You all raise your hand in Zoom, and we'd love to answer any questions that you guys may have. So please raise your hand in Zoom if you have any questions so far. But again, thank you so much, Lisa, for explaining all the terminology. Thank you so much. I think one question that I just quickly have is for this part, when a FPOA becomes effective, so when is it recommended to get a financial power of attorney at all? And does that have to do anything with like health and ease of access to technology, so someone may not need one at all? What is your take on those two questions?
So every adult should have one from the time that they become 18 years old, right? So in other words, as soon as you become aware of a financial power of attorney, you should get one at that point, because we never know when we can lose capacity. We might be in an accident or something like that. I mean, that can happen at any age. You might be in great health right now, but something unexpected might happen, and it's a good idea to have a financial power of attorney, again, to avoid the court making a determination as to who will represent your interests. With a financial power of attorney, you're saying this is the person I want to be the agent. I think I saw your hand first, Celeste.
Oh, yep, yep. Thank you so much for answering that, Lisa. Really appreciate it.
Welcome.
So yes, if you guys have any questions, please raise your hand in Zoom, and we'd love to hear from you. Thank you so much, Miss Celeste. Hope you're well. You got to make sure you hit unmute in the middle, okay?
I'm doing it. I have a question. I have a will already designed and everything, but I have two sons. So can you go over how that's supposed to be done? You said something because I had stepped away. Supposed to be in agreement as far as the financial person.
Okay, so a will is a separate document, but with regards to the financial power of attorney, you're appointing an agent, and one way you can appoint an agent is to say, so you have two sons, you can say, I want this one to be my agent, but if that one is not able to do it, or they don't want to be the agent, then my other son will be the agent. So that's a successor type relationship. You have one agent, and then if that one can't do it, you have another. Another way of doing it is to make them joint agents. In that
Oh,
case, they would have to agree. And that's not always recommended. It might be that they're not both available, or maybe they have a disagreement. You can do it that way. So you know your options, you can do it that way. It might not be the best way to do it, but you can do it.
mhm. Okay. Thank
Okay.
you for answering my questions.
Oh, you're welcome. Raymond?
Oh, thank you, Miss Celeste. Really appreciate it. And again, for any specific questions, you guys, if you don't want to specifically ask them here today, make sure you utilize the hotline number I just reshared. Yes, Mr. Raymond, thank you so much for coming on our session today.
You're welcome, Alex, and thank you for asking that question, because that was a question I was going to ask. But in addition to that, Miss Brown, you were talking about trust earlier, and I just want to know: is it the number that you posted in the chat? Can I reach out to you, because I have a personal situation that I want to discuss involving trust?
Yeah, so legal counsel for the elderly does not create trust, but if you call that hotline, when you call that hotline, is attorneys you'll be able to talk to, okay? So they'll either be able to answer your question, or they may refer you to someone else, a law firm or another organization, if you need some help
Oh,
with
okay.
drafting. But if you just have a question, they may be able to answer your question.
All right, thank you. I thought that was a number to you, but thank you for that.
You're welcome.
Thank you, Mr. Raymond. We got Miss Louise next. But yes, thank you so much for the question. Hope you're well, Louise.
I was asking a question about, I do have a trust. Do I still need a will? I have 3 children, and the first son was in charge. Then if he's not available, the second. But my daughter was having some mental health issue. So I might have to redo the thing, and my oldest son doesn't want to be responsible for her. So I have to move it to the second son. And so now I don't know if I have to just do the part that connected to her, or I have to do the thing all over again, because I don't think I need a will if I have a trust.
Okay. All right, good question. With regards to the last thing that you said, you can make an amendment to your trust. And that might be more efficient. If
Mm-hmm.
you have, if you need a more sweeping change, then you would have a restatement to your trust, which means that the whole thing would be redone. Okay, that's a restatement. With regards to whether or not you need a will to go along with your trust, generally attorneys who draft trust will include what's called a pour over will. And I just put that in the chat, a pour
Mhm.
over will. And I'll just tell you what that means
Uh-huh.
is that your trust covers assets that are put into the name of your trust. Okay, so you know you have a trust, you have to put your accounts, maybe your home, into your trust, right? But let's
Mhm.
just say you forget to put a savings account that you had from years ago, you forgot to put it in your trust, okay?
Mhm.
Your pour over will now comes into play. And what it says is, I have a trust. This is what the pour over will says. I have a trust. This is the name of my trust.
Mhm.
This asset that has to go to probate because I didn't put it into my trust, I want you to pour it over into my trust. And that avoids a whole long probate process, but
Mhm.
the asset may have to go to probate because that asset didn't get put into your trust, but it's an abbreviated process because the pour over will dictates that that asset gets poured over into the trust. So you
Mhm.
don't need a whole overall will, but
Mhm.
most attorneys will include this pour over will.
Mhm. On my finances, what I did, I put a POD on all my account. I was having trouble with my daughter once because she wants to read my account letter because her name was on it. But the bank said they had to put my name first and then their names. But I left it the same way. I just warned her, don't you touch my mail. So that's been doing pretty good.
Yeah. So right, that so like you sounds like you know if you use the pay on death beneficiary, then the individuals who are beneficiaries don't have any access before you die. Their access to your accounts only comes after you die. So that's
Right.
the difference of adding them onto your account and then having them be a beneficiary.
Yeah.
Yeah, that's excellent.
Mhm. Thank you so much.
You're welcome.
But do we have to update our um whoever signed those papers? Do we have to update it, or when it was done it was 2012? So do I have to update? You know, they said their commission lasts for so many years or whatever. Notary,
The notary. Oh, no. Just
no.
because the notary's commission ends, that does not invalidate your document. It
Oh,
just means that the notary can't be a notary for new documents until they have, re-upped their notary, but it doesn't have anything to do with the effectiveness of your document.
right. Okay. Thank you.
You're welcome.
Thank you so much, Louise. Yeah,
Mhm.
I think we're gonna go into wills and trusts in just the next few slides. So yep, I hope that also helps you out, Louise, as well.
Yeah.
Okay, we have time for one more hand, and then we'll go on. Again, thank you so much. Any financial power of attorney questions? Hey, Anne, I hope you're well. Thank you so much.
Thank you. I just wanted to tell you that it was very good that I did that financial power of attorney with my um, husband. He died, and it made everything more clear and less complicated. So I'm glad that the legal counsel for the elderly helped me do that, and I just wanted to thank you.
Thank you for sharing that, and appreciate that.
Yeah, well, it meant a lot because it was a lot of complication with children and grandchildren and me and the ex-wife, and everybody was doing all kinds of crazy stuff. So
Yes.
it was in black and white.
That's the idea. Yeah.
Yeah.
Thank you for sharing that testimony, Anne. We really appreciate it.
Okay, so we're going to talk about the medical power of attorney or healthcare power of attorney. A lot of similarities with this and the financial power of attorney, but a few differences. So for this one, of course, you're appointing an agent to make medical decisions for you. In this case, the document will only be effective if you are not able to make the decision yourself. So if you can make your healthcare decisions, then you get to make them. The healthcare power of attorney only comes into play if you can't make your own decision. Again, it's void once you die. It can be revoked or changed, but that must be done in writing. In this case, of course, the document, the healthcare power of attorney must be in writing. In this case, it must be signed in the presence of 2 witnesses. According to DC law, and a notary is not required, but recommended. Next slide. A part of a medical power of attorney is the living will or the advanced medical directive. The purpose of this document is to give instructions to medical care professionals as to what medical treatment you want if you are in a situation that they consider is end of life situation. So for instance, if you're in a coma or in a permanent vegetative state, you get to tell the medical staff in those types of situations, what kind of treatment do you want? So this is very similar to a DNR that you may have been approached with if you go into, the doctors or a hospital. You are able to say whether you want to be resuscitated. Do you only want to have pain medication? Do you want to receive all treatment for as long as you can get it? You can state whether or not you want your organs to be donated or not. You can also indicate how much pain medication you want. So you can say, I want to be made comfortable no matter what negative effects a high amount of pain medication may have on my health. I want to be kept comfortable. So those are the kinds of things you can specify in a living will or advanced medical directive. Next slide. Okay, a medical orders for scope of treatment, or MOST, is a document in DC where you can specify healthcare decisions. This one is made with your doctor. Both you and your doctor sign this document. Next slide. Okay. All right, that's all for medical power of attorneys. Any questions about that document?
Oh, once again, Lisa, thank you so much. I see the similarities and differences of the two. So again, I appreciate you showcasing the different terms in a way that we can understand. So maybe like the question before that I asked, do you recommend everyone has a power of attorney? And based on what you have said, below the power of attorney is the things like the live and will and the most that the healthcare power of attorney can oversee.
Yeah, I certainly recommend that everyone have a medical healthcare power of attorney for the same reason. We never know when we might be in a position to not be able to make medical decisions for ourselves. So, I've definitely seen younger people who might not be interested in getting a will, but they're interested in having powers of attorney done. They may think for different reasons, they may not be interested in a will, but anybody over the age of 18, I would recommend having both a financial and healthcare power of attorney.
Thank you so much for that. Lisa. We got Miss Angela for our next question, but any questions about healthcare powers of attorney? Hi, Miss Angela. Hope you're doing well. Thanks so much for coming on.
Hello. Thank you very much for that presentation. Um, Regarding the healthcare power of attorney and getting signatures, uh, I thought that I had to take the document to the notary and then have two witnesses at the notary with me. And those two witnesses have to be non-relatives, no financial responsibility. So it seems to be very hard to get two witnesses to go to the notary. But now I see on your document, you're saying the notary is not required. Could you recommend ways to get two witnesses to sign the document? Can that be done online, electronically, or what are the alternatives to getting two witnesses to help you sign the document?
Yeah. You know, well, I guess one thing you could do is you could go to the home of one of the witnesses, and then that one, wouldn't have to go anywhere. And hopefully the other witness is willing to go and, travel with you. But I'm not sure about doing this online. Notaries sometimes have the ability to uh, do a remote signing, but I'm not sure about you're doing it with two witnesses because the documents, you want to get original signatures. So I would just suggest, and you really do have to have them together because they are witnessing your signature. So they have to see you sign. The two of them were saying they saw you sign. They know that it was you who signed this document. Maybe, you can have a get together and you can have two witnesses there. In terms of who can sign, my understanding is not that it can't be a family member, but it can't be somebody who's listed in your document. So it can't be your agents, right? So as long as they're not your agents, they can sign.
Okay, thank you very much. Bye.
Thank you so much, Miss Angela. And then we got Louise, and then we'll see if there are any other questions.
I don't know if this helped, but when I work in the hospital, we had to sign those documents when the patient comes in. And we just grab a nurse here and a nurse there, or even visitor who is in the room visiting the other person. And as long as we have the two signature on there, it was okay. It doesn't have to be relative, but it can be if they're not included in, whatever paper else they have.
Absolutely. It doesn't really have to be somebody that you know because all they're doing is saying they saw you sign.
Mm-hmm.
And I'll tell you right now, nurses are less willing to do that. And, maybe, different facilities have different rules about who can sign for you. But certainly your point that it can be anybody who's
Right.
the ability to sign can do it.
Doesn't have to be a notary.
Right.
Oh, thank you so much for sharing that, Miss Louise. Thank you so much.
You're welcome.
Okay, all right, Anne, and then we'll go on. Do you have a healthcare power of attorney question, Anne?
Now I just wanted to say that when my grandmother, that was before I was involved with the legal counsel for the elderly, and my grandmother was making close to 100, and we needed a healthcare power of attorney, and we got one done, and we had two neighbors come in, and that worked out fine.
Very good. Yeah. Certainly.
Yeah, you got to do what you got to do, right?
Hey, you're on death's door, you got to do something.
Oh, yes. Thank you so much for sharing that, Anne. I hope that was helpful for you, Miss Angela. Thank you so much for asking that. All right. Okay. All right. Here's our next slides.
Okay, a last will and testament,
Is this under, would this be under medical or healthcare power of attorney or financial power of attorney if this is under either of them?
It's not, so a last will and testament is a separate document. It's a little confusing that we use this term living will. A living will is the advanced healthcare directive. That's part of a medical power of attorney. And that's different from a last will and testament.
Oh, the L. Oh my goodness. I see what you're saying. That would definitely be confusing if it's not like explained to you really. So that's thank you so much for that distinction. A last will versus a living will, which is just an advanced directive.
Right, exactly. So the last will and testament allows you to give your property, um, it may be even give words of wisdom, give whatever you want to pass down to family, friends, organizations, whomever you like. You have to have, capacity to do to have a will done for you, which means you have to know who your heirs are. Just like the other documents, you have to have an understanding of the document that somebody's helping you create. In addition to passing down things to others, you also will appoint a personal representative. So this is just like appointing an agent. That personal representative will be the person who's responsible for doing what you have, what you've specified in that last will and testament. The personal representative is responsible for carrying that out. They're also responsible for taking care of things that are important at the end of life, such as taxes and any debts or bills that need to be taken care of. Of course, distributing the property as you have specified it in the will. A will can be changed or revoked at any time before death, as long as you have the capacity to do so. And if a probate is necessary, the last will and testament will be filed after death with the probate court. And just so you know, there are individuals working to get the wills to be filed prior to death. So like if you get a will done tomorrow, you'll be able to file it with the probate court right away. In DC, that's not the case yet. So people are working on that. Right now, the rule is that the will is filed after death. The DC will require the original will. So it's very important that you or somebody else keeps up with your original will, and then you identify who you want to file that original will after death. A will must be in writing. It must be signed by 2 witnesses. A will doesn't have to be notarized, but it can be. Sometimes people will get it notarized if they think that there might be some issue. Somebody might question whether or not it's really them who signed it. So they might get a notary, but it doesn't, in DC, you don't have to have your will notarized. You just need 2 witnesses. And there is things that have to be in that document. So there is some language that's required. Next slide. Why do I need a will? I know a lot of us are familiar with there being problems within a family after someone's died without a will. That individual has not specified who they want to get what. This will kind of alleviates that, and it might be something like heirlooms or jewelry or something like that. could be even property, who you want to get that. Sometimes, during our life, we may tell somebody something, is our intention, and then later on, we might feel differently and change it. And there might be some dispute, right? So again, we're able to make gifts to charities, to friends. Often people who do have property will use what's called a transfer on death deed, and I'm going to go into that. If someone does not have a will, if they die without a will, then the state law, in this case, DC, will control how distributions are made. So whatever is in a person's estate when they die, whatever they have when they die, the DC law will control who gets it if there is no will. If there is no will, then a spouse is likely to inherit, even if the person was separated. If they told everybody, I don't want my spouse to get anything, if there's no will, then most likely the spouse will inherit. Next slide. If there's no will, what we call that, the law that, will state who gets what, we call that intestate succession. Okay. So just as an example, if a person dies without a will and they have a spouse, but they don't have any children, then they don't have any children or any parents, then the spouse will get a 100%. If they die with a spouse and children, then if those children are the same children, also the spouse's children, then the spouse will likely get 2/3. The children will split 1/3. If the children are not, the children of that spouse, then it may be divided in half to the spouse and half to children. So those rules, who gets what, go on and are specified in DC law. Next slide. There are several ways to transfer property outside of a will. And so I'm going to go through those. A transfer on death deed is an example. Life insurance, beneficiaries on accounts, like we talked about earlier. You can have beneficiaries on your bank accounts. And if you do that, probate is avoided. Also on investment accounts or other accounts. There are testamentary trusts, which means that there is no actual trust, but the will includes a statement about trust being created after death. That's called a testamentary trust. It's part of a will. And then the type of trust that many people are familiar with is a living trust. Okay, so I'm going to talk about that. That's part of the presentation. A transfer on death deed is a document that's very similar to the way that we can appoint beneficiaries on our bank account. You can have a deed that states who the beneficiary of your land or house is. That has to be recorded at the Office of Recorder of Deeds. It can be changed or revoked at any time. It again avoids probate. The beneficiary has no rights to the property prior to death, but it's a way of just stating who the beneficiary of your property or land is once you die. Next slide. Okay, and I'm not going to really go through these. So if you have a life insurance policy and you have a beneficiary listed, that also avoids probate. The life insurance proceeds will go directly to that beneficiary. Again, a testamentary trust is written into your will and often used for disabled children or minors. Next slide. All right, and I think what a number of people are interested in is a living trust. It is a way of passing property during your, you can pass the property during your life inside the trust, you're stating who is going to get your property once you die, okay? This is a document, an instrument that does not need to be filed with the court at all. So unlike a will, you do not have to file a trust with the court, which makes it a private document. It is often done to avoid probate. And a very important part of it is if you get a living trust, it doesn't really become effective. There's no teeth to it unless you transfer your property into the trust. And I'm just going to give you an example of that. So let's say I have a bank account, it's in my name, it's under Lisa Brown. All I have to do to transfer my bank account into my trust is to let my trust know, my bank know, that I want to change who's listed as the owner of my account from my name as just Lisa Brown to me as the trustee of my trust. So now the bank will have on there, the owner of the account is Lisa Brown, trustee of the Lisa Brown Living Trust. Okay, that's all that's required for my bank account to be transferred into my trust. That's also done with deeds. So you can have your house, instead of being in your own name, it can be in the name of your trust. Okay, more specifically, Lisa Brown, trustee of the trust, that's the way it would be recorded. And that's a way of transferring your property into your trust. Next slide. All right, I'm going to go through this and then I'll ask about any questions with regards to trust or anything else that I mentioned. Schedule H is a tax credit that DC residents may qualify for. You have to apply for it. There's certain requirements. It can go back 3 years, and it can help offset some other housing costs. Okay, let me see what slide is next. Okay, all right. Any questions about anything that I mentioned so far?
Oh, well, once again, Lisa, thank you so much for going all over these different documents and terms. It's really shed a light. So essentially, besides these these important things right here, you recommend that overall, everyone has a financial power of attorney, a healthcare power of attorney, and maybe an advanced directive. But for these other documents here, it just depends maybe on your assets or your certain situation? What would you say is like the overall purpose of your presentation today and some things that you recommend all to take advantage of?
Yeah. So, a mistake that I see just by talking to people is that, sometimes people think, well, I don't have a lot of assets or I don't have a certain amount of money to leave, and so they may not have a will. But, just like the powers of attorney, I think most people, it would be good for them to have a will, right? Because even if it's, our heirlooms or possessions, things that are important to us or may be important to other people. Some people have instruments, books, even pictures, right? And, I know in my family, that's a big deal, our pictures and so forth. So, you have to think about your own situation. Sometimes people will feel like, well, I only have one child and, they know what to do, but I think it makes things easier for those who are left to see in writing what you want to happen. And so I would also recommend that people get a will. If you have a will and you also have property, okay, let's just say you don't have a trust, but you have a will and you have some property, then I would suggest that you also have a transfer on death deed, because the transfer on death deed will allow that property to pass without going through probate. So a trust is one way to do that, but a transfer on death deed is another way, a very effective way of doing it, because that property will transfer immediately upon death.
Thank you so much. Yes, avoiding probate at any of these points or these processes is much preferred than going through probate due to the time and the length and some of the, especially the taxes for some of the things like properties can be avoided by having some of these documents without probate. Is that right?
Yeah, probate includes court cost.
Mm-hmm.
And it also is a public process, so anybody can go and get a copy of your will because it's a public document. Um, and so, there are many benefits to avoiding probate.
Thank you so much for that, Lisa. Any questions for Lisa? Again, time flies and we're having fun, and just this is the time to ask those questions or share any comments for today's session. But don't forget, we have a poll at the end as well. But so far, you guys have done amazing. I love all the questions and all the engagement. Thanks so much. Okay, again, we got some questions or comments for Lisa. First up, we have Anne. Thank you again for participating.
Hi, Lisa. I know you're tired of hearing my voice, but I wanted to I wanted to ask you about the Section H, because somebody asked me, and I was not sure. People who rent uh, are eligible for that. Now, is it only people who are renting in property that is not owned by the DC government?
I have not seen that as a requirement. I think it's just for people who rent and who meet the other requirements. Okay.
Okay, okay. So,
Um,
well, I referred them to the office
okay, wonderful.
because that's what Ira told me to do. So, but I thought maybe since you were here that I would ask that question.
Yeah,
Okay, thanks, darling.
sure.
See you soon.
All right.
Thank you so much, Anne. Again, the hotline is right here. Any specific comments or questions that you have that you may not want to share right here, which is definitely okay, please give legal counsel a call. I think early morning is more likely for you to reach someone. Is that right, Lisa?
Yes, I was just thinking about that. So, legal counsel um, hotline, um, they sometimes later in the afternoon, you will get a recording that says that we're not accepting any more calls. And so it is better to call earlier in the day. And if you call, you can leave a message or you'll speak to someone. Um, and you have more likely a chance to be able to leave a message or speak to someone if you call earlier in the day. Later, you may get a recording saying that we're not accepting any more calls. And if that happens, just call the next day, but try to do it early in the day.
What are the hours of the hotline?
I think it's 8:30 to 4. If somebody knows better, let me know, but I think it's 8:30 to 4.
Okay. I just wanted to put that in the chat for everyone as well. I wish Robin was still on. No, it's okay. But yeah, earlier in the morning is a-okay. Yeah, we have three more hands. Thank you so much. Again, any other questions or comments today, please raise your hand, or you can call the hotline, okay? We got Mr. Raymond. Thanks so much for coming on.
Yes. Lisa, you were given an example of a trust, and it was kind of confusing to me because when you so if you wanted to say put your bank account in a trust, you would first open a trust uh um in your name, meaning Lisa Brown, and then put that trust in the name of Lisa Brown.
Yeah, it's confusing. You're right. So if I was going to create a trust, then I would be the grantor, so which means it's my trust. Okay, so there's certain terms that go with the trust. All right, grantor, trustee, beneficiary. Okay, if I create a trust, a living revocable trust, which means one that I can change and the one that most people are familiar with, then I'm the grantor. I'm also going to be the trustee. If I'm the trustee while I'm living, then I can make any changes I want to that trust. Okay. And during my lifetime, I'm also the beneficiary. Okay. But when I die, somebody else becomes the trustee, somebody else is the beneficiary. But a trust has a name. So you could name it anything you want. So if I create a trust, it could be the Lisa Brown Revocable Trust. It could be, I can make up a word. It could be the X Fox Revocable Trust or just trust. It could be anything, but it will have a name. So when I go to put an asset in the name of the trust, then it's going to have that name. So, but it'll also really be in the name of the trustee. So since I'm the trustee, it's the Lisa Brown it's Lisa Brown, trustee of the X Trust. Okay.
Okay. Okay.
And
With it.
that just means that the asset goes from my name as me as an individual to me as trustee of my trust.
Okay, so I have that part. So what happens to that trust after you die?
Okay, so a major part of it is that you are indicating successor trustees. Who's going to be the trustee after I die? So I'm going to list my son, my daughter, my other son in succession.
Okay.
My oldest son, then my daughter, then my younger son. Okay, so as soon as I die, the trustee has immediate access to all of my assets that are in the trust.
Right. And it doesn't have to go through probate.
Exactly.
Thank you. That's my question. Thank you so much. And thank you for all that you do.
Oh, thank you. Appreciate that.
Mhm.
Thank you, Mr. Raymond, for that question. That makes complete 100% sense. It avoids probate. It's real quick, pretty easy, amongst the other benefits. So that was a great question. And yeah, the family members might need that money from that bank account as soon as possible. So, just thinking of why this would be useful is very easy. So thank you for asking that. We got Louise once again. Thank you so much for all the great questions, everyone.
I want to ask a question about if you have a home in another state and you have a trust for DC, can you have that property in another state into the trust without going to that state for a lawyer?
Okay, so really, people who have property in another state,
Mhm.
I think they're amongst it's really a good idea for them to have a trust, okay? And the way it works with property in another state is that you contact a lawyer in that state over the phone. You don't have to
Mhm.
go there, right?
Mhm.
You let them know about your trust. What they will do is pull the deed from the courthouse where your
Mhm.
property is located. They
Uh-huh.
will put that property into the name of your trust, right? And you will sign the new deed. You may be able to do that remotely using a notary because it'll have to be notarized also. Or they may send it to you in the mail. They'll send you the trust, the new
Mhm.
deed, and you get it signed and notarized, give it back to the attorney, and he will file it in the court where your property is located. Even though your trust is in DC,
Mhm.
your property out of state can be in the name of your trust that was created in DC. And it's really important to do that because now the, nobody has to go through probate in that other state,
Right.
right? The trust keeps them from that. And that can be even more convenient than your property right where you live, right? So
Mhm.
but that's a great question. But you can pull the deed yourself, but having a lawyer doing in another state is probably efficient because it doesn't cost very much to do that. It's a couple $100
Mhm.
to have a deed done in the other state, and they'll get your old one, they'll file the new one, and so it could be helpful to use a lawyer.
Oh, okay. Thank you so much.
Thank you, Louise.
Yeah,
Mm-hmm.
this is great.
Yes. We got Gracie next. Hey, Gracie, hope you're well.
I'm good. Thank you. Miss Brown,
Yeah.
I was trying to get my house in order. I know you know what I'm trying to say. And I had some stock that I didn't have a beneficiary named. So I sent for the designation form, and on the form, it says that they will not accept it if I went to a notary. I would have to get a medallion stamp. And so I called them and asked them because all of the others, if I had it notarized, they accepted them. And they are saying he couldn't explain it to me where I understood why it was necessary to do that. So I just said, maybe I'll just put this person in the will and give them the stock that way. Would that suffice, or should I go and try to get to the bank and get that medallion stamp?
Well, I think it might be a little more work for you now, to go to the bank and get that done, but it will save your beneficiary a whole lot later.
Oh, okay.
I would suggest that you do that.
All right. It's a little difficult to get, but I can get somebody to take me, I'm sure. Okay. I appreciate you. Thank you.
Absolutely.
Thank you so much, Gracie. Yep. Any other questions? Any other comments for today? Please raise your hand in Zoom. We got two more hands. Okay, we got Anne. Thank you again for sharing.
I'm back again, Lisa.
We love it.
I wanted to ask you a question. Is it possible do I have to put a codicil to the will if I want to leave something to my grandchildren?
Yes.
Okay, so when I talk to somebody at the office, because you all did my will. Okay.
Yeah. So
Okay.
you can either have the document redone and just include that in there, or you can, have an amendment done, as a codicil. So, and since we already have the document, it might be, as easy to just redo the document.
Okay. All right. I'll talk to you then. Thank you. And about the house in another city, huh? That what you just gave is advice we needed 15 years ago. Okay.
Oh.
Okay. Yes, I know. There's a lot of property, in other places where, our family is from and all that.
Well, it was something that we didn't even know that was ours.
Okay.
Okay, because after Katrina, a lot of things went on in New Orleans, and so it was really something. I found out a whole lot of stuff that and it was complicated, and I didn't have legal counsel for the elderly to give me a hand.
Mhm,
So down there, so it was kind of complicated, but and that's why I was asking you about that and the grandchildren, because Louisiana law is a little bit different from around the country because they still have stuff on the books that are French laws.
yeah.
Hmm.
Mm,
Okay, thank you, Lisa.
You're welcome.
yeah,
Hmm.
so much. We got two more hands. Thank you so much, you all, for the wonderful comments and questions today. Hey, Mr. Raymond, once again, we really appreciate it.
Yeah, I'm back again. Uh, and what spurred my curiosity was this term. Man, now it left me. What's the difference between a notary and this other thing that this lady has to get from her bank? What was it called?
I think she said a medallion.
Yeah, medallion. What's the difference in a notary and a medallion?
I'm not completely sure, but let me just tell you what I think
Mm,
they may be referring to. And then whoever asked that question may know better, so correct me.
Mm-hmm.
Sometimes the notary now, they change their policies. And so sometimes they will notarize and there won't be, how you feel that raised part to their stamp that they make that stamp and it has that raised thing so you can tell it's an original.
Mm-hmm.
Yeah. And so now sometimes when they do the stamp, it doesn't have that, you know.
Oh,
Um,
really?
yeah, and it's just, they just sign and they have their stamp, but they don't have the raised part. So I'm thinking that maybe it has to do with that. They're saying that it has to specifically be something where you can feel that it's the original. But
Mm-hmm.
correct me if I'm wrong, whoever mentioned that.
Okay. They're probably muted.
Okay, yeah. Gracie, did you want to speak on that?
Ms. Brown, he didn't say anything about the notary, but what he did say, upon my death, uh, the money would be transferred to that account, I guess at the bank, wherever you have the stamp from. But I told him, suppose that person is not affiliated with that bank. He said, well, all I can tell you is that's our policy. So he couldn't really, go into any more detail, to make me understand better why it had to be the bank or financial institution that gave me that medallion stamp. So that's why I was asking you. So just to be on the safe side, I will go get that stamp. I might not can do it right away, but as soon as I can, I'll get there in the bank and have it stamped so that it won't give the beneficiary any problems.
Oh, okay. So it sounds like he was saying that it had that notarization or whatever, that confirmation that it was you had to come from a bank and not just a mobile notary. Or sometimes there's notaries at UPS or whatever that
Mm-hmm.
had to come from a bank.
Yeah,
Mm-hmm.
yeah. And I'll inquire at a bank to just get that clarified. But thank you.
Thank you both. Really appreciate it for your question and for your assist, Gracie. We really appreciate it. I see your question in the chat. We're going to hear from Miss Celeste first, and then that'll be our last question. Hi, Miss Celeste, once again.
How
Thank you
are
so
you? I just wanted to make a comment saying it's very good, Miss Brown, that you're on here because helping friends and not having a will is very difficult for them. But a will is important, especially as you get older. And legal counseling is one of the ones that is really good at that. But thank you for coming on and having a will. And I love my will and I change it every now and then. But
Yeah,
thank you.
updating. Yeah, yeah,
Mhm.
thank you. Appreciate that. Yes, it's important to have.
Yes, it is.
Well, thank you so much, Miss Celeste, for sharing. I love all the testimonies today, you guys. Thank you so much for sharing. And then I think, yeah, this is a great question. I think, does legal counsel for the elderly assist in filling out wills and trusts for seniors? And if they do, at what cost?
Okay. So legal counsel does help with wills if the individual qualifies for the service, which means they are over the age of, they're 60 or older, or, I mean, for will, they need to be 60 or older. Also, they need to meet a certain income requirement, okay? And that income requirement changes year by year. I have it in my office here that for a person who is single, one person in a household, the annual income is requirement is $39,125 this year. Okay, and so there's other, if you're they have more people in your home, it's going to be a different amount. But when you call legal counsel for the elderly, they can go over with you whether or not you qualify for the service. If you do, there's no fee. So all the legal services provided by legal counsel for the elderly are free. We do not assist with trust. But if you call that hotline, it may be able to refer you to somebody who can help you with the trust.
Thank you for that, Lisa. I hope that answered your question here in the chat. Uh, but yes, wow. Well, thank you so much, Lisa, again for presenting this information for us today. I love the format and those questions, and we're always surprised by them because they're so amazing. But that just goes to show how different folks may be in their circumstances and situations, and what they have and what they may not have, and the terminology, and it can get really confusing for a lot of people. So myself included. So it's always nice to have someone to do a refresher and to go over some of these things. So for your session today, what do you if you're able to, what do you see the most, or what do you think a lot of DC residents lack or may need more assistance with, and maybe some key points from your session today?
Okay. I would say one of the things I think comes up a lot is people waiting to get their documents done, and then, waiting until it might be too late. You can only get these documents done when you have capacity, right? When you're able to understand the document and understand who you're choosing. So I would say, talk to people who you know and encourage them to get these documents done. And not to have fear about talking about, being in a situation where they can't make a healthcare decision, or they die, because a lot of people are, nervous about discussing it, and I think that's why they wait. So just, talk about it. If you have the documents done, let people know that you do. that getting these documents doesn't make anything bad happen to you, you know. And also so you know specifically about me, I actually work with individuals who are homebound, or, you know, who are in a hospital, nursing home, assisted living facility. And I say that so that, you know, that even, you know, people who can come to the office are helped by legal counsel for the elderly, but even people who cannot, are, you know, helped with these documents as well. So if you know somebody who might be thinking they can't get it done because they can't leave their home, then let them know that we do have a service, where we can help individuals, um, you know, with these documents. And as you know, there are all kinds of ways to get, these documents done. And some people do, use online services. I see Angela, mentioned that. I think some people like being able to talk to an attorney and ask questions specifically, and so I think that's why some people, go to, an attorney to get it done. But there are many ways, to get these documents done. If you specifically want our help, then you see the number there. And I just want to mention that I really appreciate having the opportunity to present to you all. You all are a great group, very engaging, and you did a wonderful job with, International Be Kind to Lawyers Day. I feel great.
Thank you so much, Lisa. Well, we can't wait for legal counsel's next session with us. Again, we always take something, and just as Lisa said, please share this information with your community members, your friends, your family. Just like she said, if you have it, you can let others know that you do, and it encourages them. And you know, it's a topic that may be a little taboo or a little sad, but it's normal. It's human life. So. You know, I feel like once more people talk about it, the more normal it is. But as you can see, you can help out in so many assets for yourself and for your family, as well. So really appreciate you coming with us today, Lisa. Again, make sure you give them a call, 202-434-2120, if you need any assistance with some of these major things that they work on us with. Make sure you stay on for our poll for our session. And let's all say a very big thank you to Lisa for the session today. Thank you, Lisa.
Thank you, Lisa.
Thank you. Thank you,
Yay.
Lisa.
Bye,
Thank you so
Lisa.
much,
Oh,
Lisa.
Thank you.
Thank you, Lisa.
Thank you.
Thank you. That was very good.
Have a wonderful day, Lisa.